We're on the record. My name is Gary Wade. I'm a videographer employed by Wade Enterprises, located at 166 North Eckhoff Street, Orange, California. This is the video recording of the deposition of Michael Avenatti, Volume 2. We are starting at approximately 9:51 a.m. on September 28, 2015. At this address, 1851 East 1st Street, Suite 1600, Santa Ana, California. This is the matter of Meghann Avenatti, LLP versus Robert J. Stoll, Jr. et al. And related cross actions. Case number 30-2011-00483570, consolidated with 30-2013-00627604. This deposition is taken on behalf of the defendant. May we have the introductions, beginning with witness. Can you please state your name?
Yes, Michael John Avenatti.
Phil Baker for plaintiffs.
Bob Stoll.
Jaems Keathley on behalf of Robert Stoll and Stoll, Nussbaum, and Polikoff.
And Honorable R.J. Polis, retired as discovery referee by invitation.
Will the court reporter please swear in the witness?
You do solemnly swear that the testimony you're about to give in the cause now pending shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Good morning, Mr. Avenatti.
Good morning, Mr. Keathley.
As you know, this is the continuation of your deposition that started in April of this year, correct?
Yes, sir.
Okay. I'm going to show you a document which we'll have marked as Exhibit 23. It's the notice of taking continued deposition of Michael Avenatti. Work that. Take a look at it. Sorry. Take a look at it and let me know when you're finished.
Okay, I've had a chance to look at the notice. I have not had a chance to look at the exhibits yet.
Did you produce any of the documents contained within the notice?
Well,
Okay.
I will submit an objection. This was hand-served on us last Thursday, September 24th. Didn't give proper notice. We did submit an objection, a timely objection, the very next day, which was served on Mr. Keathley's office.
The answer to your question, Mr. Keathley, is that I have not brought any additional documents with me today beyond what's already been produced.
Okay, I'm going to mark as Exhibit 24 the objection to the deposition. Show it to the witness.
I think we have an extra copy. I'm going to hand that back to you.
If you want a copy of it.
Do you want me to read this?
No, I just wanted to
Put it on the record.
put it in the record. And for the record, since this is a continuation of the deposition, the notice was timely in so much as we did not agree to the deposition till today's date, until Thursday via email, and all of the objections which are contained within the objection have all been previously ruled upon and have been overruled. There's also no privilege log. So we'll deal with that. in due course. I'm going to show you another document which will mark as Exhibit 25. It's a letter dated September 17th, 2015, from Mr. Baker to my office. Take a look at it, Exhibit 25, and let me know when you're finished.
Okay.
You familiar with this letter?
I'm generally familiar with the fact that a letter was sent around this time.
Okay, my question was, are you familiar with this letter? Exhibit 25.
I think I may have seen it before.
Okay. If you look down at item number 3, with respect to the documents that were produced, date stamped CL 000001 through 56/9/45. Do you see that, sir?
Yes, sir.
Did you personally review all of those documents that were produced?
The 57,000?
Yep.
Did I review them prior to them being produced, or did I review them during the pendency of the case, meaning the underlying case that we're here today about?
Prior to them being produced pursuant to the request for production of documents.
During the course of the case, I'm fairly confident that I had some interaction with those documents, reviewed them, looked at them, discussed them, etc., but I did not review all of those documents before they were produced in this case.
Then you are not aware as to whether or not all of these documents are responsive to the request for production of documents for which they were produced. Is that correct?
I believe that the documents that were produced are responsive, but I was not in charge of the document production.
Who is in charge of the document production?
Mr. Sims was primarily on point as it related to that issue.
If you turn to the second page, please. Paragraph indicates, finally, please be advised, we are presently expecting to file a petition with the California Supreme Court regarding the attorney-client privilege issue that was the subject of our writ. Accordingly, documents covered by that privilege that are part of the file have not been included. Are there actual documents which are being held as attorney-client privilege?
Yes, I believe there are.
How many documents are there?
I don't know the quantification.
Do you have an estimate?
I do not.
And why were those documents not produced today?
Well, I think the document speaks for itself. We are considering filing a petition that arose from Judge Polis's initial ruling on the attorney-client privilege.
But you understand there has been no writ or petition filed as of today's date, is that correct?
That is correct.
And you have not applied for a stay, correct?
I'm not sure why this is being part of the deposition. I'm not being deposed, but no, we have not filed a motion to stay. You know the record, my good friend.
I do, and that's why this deposition is going to be concluded today. I don't have the documents, so we'll just have to do what we have to do.
Okay, sounds good.
Are you done with this?
I am, thank you. I'm going to show you another document which we'll mark as Exhibit 26. It is Michael J. Avenatti's second supplemental responses to special interrogatories, set number 1. Thank you. Take a look at this document and let me know when you're finished.
I've seen this document before.
If you turn to the very last page, the verification, is that your signature?
Yes, it is.
And prior to signing the verification, did you read the contents of these responses?
Yes.
Turn to page numerical 2. I'm looking at the second supplemental response to interrogatory number 37. Do you see that?
Yes, sir.
Okay. When did you first contact Ellen Pansky of Pansky and Markle?
In connection with this matter,
Yes.
sometime in the month of May of, I believe, 2011, if I have my year correct.
And what was the purpose in contacting Ms. Pansky?
To seek her advice and counsel relating to a potential dispute with Mr. Stoll relating to the attorney's fees from the underlying FLIR case.
And how did you contact Ms. Pansky?
As I recall, I called her on the phone.
Was anybody else present in the with you when you spoke with Ms. Pansky on the phone?
I had a number of discussions with her on the phone, and I don't recall anyone being present on my end other than myself.
How many conversations did you have with Ms. Pansky?
Relating to this matter,
Correct.
I would say 3 or 4, but it was a long time ago.
Over what period of time?
As I recall, it was a couple weeks. It may have been shorter than that, it may have been longer.
Did you take any notes of your conversations with Ms. Pansky?
Not that I recall, but I may have.
And those notes have not been produced today, is that correct? If you have them.
I don't know if those notes even exist. I haven't found any notes. I've looked for notes.
How long was the first conversation that you had with Ms. Pansky?
I don't recall.
Give me an estimate.
Not as I sit here today.
What did you discuss with Ms. Pansky on the very first phone call?
I explained the situation, namely that the clients had terminated Mr. Stoll. We discussed Mr. Stoll's conduct in the case. We discussed his conduct at the settlement conference. We discussed the 200 agreement that did not comply with 200 or Chambers v. K. We discussed the settlement of the underlying case. And we may have discussed other things, I just don't recall as I sit here today.
What did you say specifically to Ms. Pansky regarding the situation as you testified to?
Well, I don't recall specifically the exact words that I used because it was some time ago, but I do recall explaining to Ms. Pansky that Mr. Stoll either had been terminated or was about to be terminated from the case due to his conduct in the case, etc. And I asked Ms. Pansky what my obligations were relating to that termination, the settlement proceeds, apportionment of the proceeds, etc.
What did you specifically tell her, Ms. Pansky, about the conduct of Mr. Stoll?
I told, what I told Ms. Pansky is consistent with what I stated in my, the first volume of my deposition relating to Mr. Stoll's conduct in the case. Namely, that he had not done what he was obligated to do, that he had not fulfilled his end of our agreement, that the clients were very upset. We discussed his conduct at the settlement conference, wherein he advised the clients not to report the settlement proceeds. And we discussed that Mr. Stoll was continuing to claim that he was owed $5.4 million despite all of this conduct and despite he and his firm doing very little, if anything, in the case.
And what did Ms. Pansky say, if anything, regarding Mr. Stoll's conduct?
I don't recall if she made any comments relating to his conduct.
Did you send Ms. Pansky any documents?
I may have. As I sit here today, I don't recall.
You do not recall whether or not you sent her a copy of the retainer agreement?
I have a vague recollection that I did, but I can't state with absolute certainty that I did.
Did you recall whether or not you sent her a copy of the fee-sharing agreement?
Same answer.
Did you send her a copy of the termination letter?
I don't think that document was sent to her. But again, it was a long time ago. I may be wrong about that.
Did you send her a copy of Mr. Grassini's letter to you in June of 2011?
I don't recall.
Did you send her a copy of Exhibit 10 to your deposition, which is the June 6, 2011 letter to Mr. Panish, I'm sorry. I'll give you a copy of Exhibit 10, so you may review it.
I may have, as I sit here today, I just don't recall. Do you want me to hold on to this?
We'll put it in front of you because we're going to be looking at some documents periodically. What did you tell Miss Pansky was Mr. Stoll's obligation with respect to the floor matter?
Again, I don't recall specifically the exact words that I used, but that, namely, Mr. Stoll was supposed to do, at a minimum, his share of the work on the case, and that he and his firm had failed to do that. What little work they did do was completely substandard, and I think that's my answer.
Did you specifically tell her that what you believe the minimum amount was 35% of the work to be done?
I don't recall.
Did you send Ms. Pansky a copy of Exhibit 19?
You gotta remind us what that is.
It's the term,
Okay.
it's a settlement term sheet. It's in the deposition transcript.
Okay.
I don't believe so. Again, I may have. I just don't recall.
How long did this first conversation with Ms. Pansky last?
I don't recall exactly. It was less than a half hour.
Tell me everything that she said, Ms. Pansky said, during this 1/2 hour or so conversation.
Well, again, I don't recall the specific words that she used. I think during that initial call, Ms. Pansky mostly listened in an effort to gather information as to what the situation was. In my experience with Ms. Pansky, she's not prone to providing immediate advice.
Have you used Ms. Pansky on other cases than this one?
Ms. Pansky serves as outside counsel to the firm and has served as outside counsel to the firm since the firm's inception in 2007. Prior to that, and she also serves as outside counsel to me and other individual attorneys at the firm. Prior to that, I had used Ms. Pansky in connection with my employment at Green Broilette, Panish and Wheeler at the time, as had Green Broilette, Panish and Wheeler. She served as their outside counsel.
How much money have you paid Ms. Pansky for her opinions?
I'm not sure that's
Very
relevant,
excuse.
Your Honor. How much he's paid Ellen Pansky?
Can I have the question read back?
How much money have you paid Ms. Pansky for her opinions
Regarding this case.
in this case?
Oh.
Well, I don't think we've paid anything to Ms. Pansky for her opinions in this case. I think that we sought Ms. Pansky's advice and counsel as a well-regarded ethics attorney in the state of California. And as I sit here today, I can't tell you what she was paid for that. I don't know.
She wasn't giving you her advice and counsel for free, was she?
Not that I recall.
What did you tell her with respect to the fee-sharing agreement not complying with Rule 2200 or Chambers v. K?
Well, we discussed that point. I don't recall exactly what I said, but I did express to her a concern that that agreement did not comply with 2200 and Chambers v. K because it did not delineate which firm was supposed to do what, number one, and number two, it did not state that it was a pure referral arrangement, which was Mr. Stoll's position at the time, namely that it was a pure referral arrangement and that he nor his firm need do anything in order to get 35% of the fee.
And what did Ms. Pansky say, if anything?
During that discussion, I don't recall what she stated as it related to that issue.
When was the next conversation that you had with Ms. Pansky regarding this matter?
I don't recall exactly. It was probably within a few days of the first call.
Did she call you or did you call her?
I have no idea as I sit here today.
Did you take any notes of that second conversation?
I may have. I've looked for notes. I haven't been able to locate any.
How long did that conversation last?
Less than a half hour.
What did Ms. Hansky say during that less than 1/2 hour telephone conversation?
Again, I don't recall specifically the words that she used, and it's unclear to me, Mr. Keathley, as to what was discussed during which discussion, because there were a number of discussions over a few weeks period of time, as I recall. It may have been 10 days, it may have been 3 weeks. I don't recall the exact time frame. But generally, at some point, Ms. Pansky advised me that the monies did not have to be segregated, number one. Number two, that I was not permitted to pay Mr. Stoll what he was demanding due to his termination, and that I should ask Mr. Stoll as to what he believed he was entitled to under quantum merit theory.
And did she say why she was advising you not to pay Stoll?
Because he had been terminated by the clients, and therefore I was not permitted to pay him the amount of $5,460,000 as he was claiming.
Did you tell Ms. Pansky that Mr. Stoll was allegedly terminated on May 31st, 2011, the same time that your firm received the $39 million in settlement proceeds?
I told Ms. Pansky as to when Mr. Stoll had been terminated in the first discussion, as I recall. It was either the first or the second, now that I'm thinking about it. But in one of those early discussions, we talked about the timing of Mr. Stoll's termination and the timing of his conduct at the second mandatory settlement conference.
What did you discuss about the timing of Mr. Stoll's termination?
Just that, the timing, namely as to what had transpired. I don't recall exactly.
Did you discuss with Ms. Pansky how much further work needed to be done on the file after Mr. Stoll's firm was allegedly terminated?
We did discuss the fact that the case was still ongoing, yes.
What did you tell her about the case being still ongoing?
Well, I explained to her that Latham and Watkins had been dismissed without prejudice from the underlying case, and that now that the claims against Fleer had been put behind us effectively, that we were then going to proceed with claims against Latham and Watkins, and that the matter was going to continue. And that it was the specific matter as outlined in the attorney fee agreement that was originally signed with the clients.
Signed at the...
Signed with the clients, I'm sorry.
Did Ms. Pansky give you any statutory or case authority for not paying Mr. Stoll?
She may have, I just don't recall as I sit here today.
Did Ms. Pansky, what did Ms. Pansky tell you about not having to segregate any of the money being claimed by Mr. Stoll?
Well, just that the monies need not be segregated under the circumstances, and she inquired as to what Mr. Stoll's position was as to what he would be entitled to under a quantum merit theory. And I told her that we had repeatedly asked those questions and that he refused to tell us.
And this conversation took place in May of 2011, is that correct?
No, this conversation likely took place in June 2011. Again, I want to be clear about something. There were a number of discussions over a period of time. As I recall, the first discussion was in late May. It might have been right after the 1st of June. I just don't remember. The conversations continued into the month of June. And as I said earlier, this was a long time ago. So something that I have stated that was said in the second conversation could have been, in fact, stated in the first or in the third conversation. I'm doing the best I can under the circumstances.
I understand, I appreciate that. Did Ms. Pansky cite you any statutory or case authority for not having to segregate any of the monies that Mr. Stoll was claiming?
I'm sure she did. I just don't recall what that was as I sit here today.
Did Ms. Pansky give you any authority for indicating that you were not permitted to pay Mr. Stoll or his firm due to his termination?
Same answer.
Prior to this second telephone conversation, did Ms. Pansky provide you with anything in writing regarding her opinions?
I don't recall one way or the other.
When was the next time you had a conversation with Ms. Pansky?
Again, I think it's sometime in June.
What's the difference in time between the second conversation and the third conversation?
I don't remember.
You have the best estimate? A day, 2 days?
Not as I sit here today.
Did you call her or did she call you?
I do not remember.
Was it a phone call that you had with her
Yes,
versus
sir.
a live meeting?
It was a phone call.
How long did that telephone call last?
Less than 30 minutes.
And what did you say during this 30-minute, less than 30-minute telephone conversation?
Generally what I've already testified to.
What you testified to today? Is that what we're talking about?
Yes.
And what did Ms. Pansky say during this second 30-minute, less than 30-minute telephone conversation?
Generally the same thing.
Did she provide you with anything in writing regarding her opinions between the second telephone conversation and the third telephone conversation?
I don't recall.
Did Ms. Pansky provide you with anything in writing at all containing her opinions?
I don't recall.
Did you provide Ms. Pansky anything in writing that outlined the work that was done or not done by Mr. Stoll or his firm?
I don't recall. I don't think so.
Did Ms. Pansky ask you for any documentation during any of the telephone calls?
I'm sure she did, in keeping with my prior experiences with her, but I don't have a specific recollection of her doing so.
You don't recall if you provided her with the dismissal of the Fleur case?
I'm fairly certain that I had not provided her with the dismissal because the dismissal had not been entered and was not valid as of the time that I spoke with Ms. Pansky, as I recall. But again, the timing of these discussions is difficult for me to pinpoint. But as I recall, the dismissal did not take effect until well into the month of June.
that you provide Ms. Pansky with a copy of the settlement agreement?
I don't believe so. Because I can recall being concerned about a confidentiality issue related to the settlement agreement.
Was there a fourth telephone conversation that you believe you had with Ms. Pansky?
There may have been. I have a vague recollection that we spoke 3 or 4 times. It could have been 3, it could have been 5. I certainly don't think it was more than 5. I just don't remember.
And basically the sum and substance of either the fourth and fifth are going to be close to what the first, second, third were?
Generally speaking, yes, sir.
Can you make any distinctions between the generality of the first, second, third with regard to the fourth or fifth? Is there anything that sticks out in your mind?
Not as I sit here.
Did you ask Ms. Pansky for a written opinion regarding her opinions concerning Mr. Stoll?
No,
Why not?
because I've never asked Ms. Pansky for a written opinion in connection with any issue that I have ever brought before her, and I didn't believe that I needed it, and I was confident in her and her abilities, and I didn't think it was that complicated of a situation.
Did Ms. Pansky agree with you with respect to whether or not the fee sharing agreement complied with Rule 2200 and or Chambers v. K?
I don't recall.
Recall if you provided Ms. Pansky with any emails from Mr. Parrish or Mr. Fitzgibbons to Mr. Stoll regarding his firm's conduct in representing him during the floor matter.
I just don't remember.
Did you tell Ms. Pansky that the distributions of any of the attorney's fees were directed to you by Mr. Parrish and Mr. Fitzgibbons?
I may have. I just don't recall as I sit here today.
Between Mr. Parrish and Mr. Fitzgibbons, who actually directed you to distribute the attorney's fees?
Well, I think that's privileged. Obviously, it's an issue that we've had about the termination and the continuing attorney-client relationship Mr. Avenatti had with Parrish and Fitzgibbons. So at this point, I'd instruct you not to answer.
Can you give me 1 minute?
As an attempt to accommodate Your Honor, I'll let him do it subject to this not being a waiver of the privilege, and that if the privilege is upheld in our petition, this testimony can't be used before your honor or any trial court, if that's acceptable.
And that there is an agreement that the fact that I'm being permitted to answer these questions is not going to be made as part of some argument that the privilege should be.
I didn't hear what he said.
Okay.
You'll have to repeat it.
And the fact that he's answering this can't be deemed a waiver of the privilege, because we're reserving our right to move via our petition. But I don't want any testimony to be deemed either by you or by the court as a waiver. Subject to that, I'll let him answer if that's agreeable, Mr. Keathley.
It's not agreeable to me because there is currently a court order and the fact that there is no attorney-client privilege. You have not yet filed a petition with the Supreme Court and there's no stay.
Okay, if he's,
Okay, I can say it's agreeable to me that I can deem no waiver, but I'm not the boss.
okay, well, I mean, we're willing to testify to that. If they're not willing to, with that proviso, we were ready here to answer any and all questions regarding that. So without that agreement, I guess I have to instruct you, unfortunately.
So you're instructing your client to go against a court order, is that correct?
I think my position's clear. We have appellate rights that we're going to pursue. We disagree with your educated decision, Judge,
Let's not argue about this.
but if they're not going to agree to it, you can't answer.
Yeah, the objection would be overruled just for the record, but the record stands as it stands.
Can we have that stipulation so that we can at least get on with this, Mr. Keathley? I mean, I don't see any downside risk here. I'd like to conclude this.
Well,
I mean, I don't understand what you're giving up.
why don't we go off the record?
You want to talk with your client?
We're going off the video record. Time's approximately 10:33 a.m. We're back on the video record. Time is approximately 10:39 a.m.
I will agree to the stipulation as proposed.
You said I will?
I will
Okay.
agree to it, so we can get this thing over with. And I'm assuming this is going to be, to the extent you have not filed your petition, the same type of stipulation regarding Parrish and Fitzgibbons?
Yes.
Depositions?
Yes.
All right. Now, with that having been said,
I don't understand that last part.
That would take the same position if Parrish and Fitzgibbons are deposed on this.
Okay. Yeah, I can't imagine the position is going to be any different, but I'm here today to answer questions.
I understand that. With respect to, between Mr. Parrish and Mr. Fitzgibbons, who directed you to disperse the attorney's fees?
Both of them.
Was it in writing?
It may have been, I don't remember.
Did you write a confirming letter to Mr. Fitzgibbons and Mr. Parrish regarding their directions to distribute the money?
Same answer.
Is this in one of the writings that you are withholding under the attorney-client privilege?
Let me be clear. My answer is I don't remember. I may have done that.
Did you review any of the documents which Mr. Baker indicated in his letter, Exhibit 25, that are being withheld under the attorney-client privilege?
When?
For prepping for this demo?
Well, before the documents were produced, before September 17th, 2015.
I don't understand the question.
Okay. Mr. Baker, in his letter of September 17, 2015, indicated that certain documents were not being produced because they were considered privileged under the attorney-client privilege. My question to you is, did you review those documents on or about September 17th, 2015?
No.
Did you review them prior to the preparation of Exhibit 25?
It's this letter.
Well, at some point I did, because I believe I'm party to those communications, many of the communications. So at some point back in 2011, for instance, or whenever they would have been utilized, I would have been aware of them. I don't think I quite understand your question.
Maybe let me do it this way. In preparation for the production of documents, which is the subject matter of the September 17th, 2015 letter, did you look at all of those documents that are being withheld under the attorney-client privilege?
No.
Thank you. When were you directed by Mr. Fitzgibbons and Mr. Parrish to distribute the attorney's fees?
I don't recall the exact date. It would have been sometime in the May or June timeframe.
What did Mr. Fitzgibbons or Mr. Parrish tell you about distributing the attorney's fees?
I don't recall exactly what they informed me to do or told me to do.
Do you recall in general?
No,
Did you,
not without looking at other documents.
what other documents would you look at in order to assist you in recalling?
I can't answer that. It's pure speculation.
Did you receive anything in writing from them regarding the distribution?
Same answer. I think you asked me that moments ago. I may have, as I sit here today, I just don't recall.
Of the attorney's fees, there was $15,600,000 that were to be allocated towards attorney's fees. Is that correct?
I don't recall the exact number.
Does that sound correct to you, though?
Same answer.
And $5,250,000 was paid to Mr. Panish's firm. Is that correct?
I don't recall the exact number.
How much was paid to your firm?
I don't recall the exact number.
Do you have an estimate?
Not as I sit here today without looking at additional documents.
What additional documents would you look at?
Same answer as before. It's speculation. I think documents have been produced relating to that issue. In fact, I'm almost certain of it. So without looking at those documents, whatever's been produced in the case, I can't really answer that question.
The documents that you would have to look at, would those be the Citibank and Trust documents?
City,
No, California Bank and Trust documents?
No. My answer stands as I previously stated.
So you guys, you sit here today, you have no idea what documents that you would have to look at in order to determine how much your firm got paid as attorney's fees in the Fuller matter.
Asked and answered.
That's incorrect.
Okay. Tell me what documents you would look at to determine how much your firm got paid.
I'm going to rely on my prior answer to the question, Mr. Keathley.
Which was you don't know?
No, that's your answer. My answer is as stated on the record, sir.
Why don't you just repeat it for me again, because I must have misunderstood it.
There's been documents produced in this case that I believe show those amounts. I don't have the documents here in front of me. I'm sure that you have the documents. So those are the documents that I'm referencing.
But as you sit here today, you can't identify a single document
Asked and answered.
that would, let me finish my question
Sorry.
first, that would tell you how much money your firm was paid. Is that correct?
Sir, I am sure that those documents exist. I know that they've been produced, but I cannot give you the exact title or bait stamp number of a single document. But that does not mean it does not exist, because I'm sure that it does exist.
I'm not asking for the exact bait stamp document. I'm asking, is it a letter? Is it an agreement? Is it some sort of other writing, email?
I can't provide any more illumination on this topic, Mr. Keathley. If you have some documents you'd like me to take a look at, I'm sure I can answer your question.
Go to page 7, if you would, on Exhibit 26, your responses to the second supplemental responses to the interrogatories. And if you look at the second supplemental response to interrogatory number 48, do you see that?
Yes, sir.
148.
148. Going down to the second sentence, it said this amount was deposited into the firm's bank account at California Bank and Trust, account number 32601578849, in approximately May of 2011. You see that?
I see the sentence.
Is that an accurate statement?
To the best of my knowledge, it is. The account number may be wrong, but I think it's correct.
Why was that amount of money, the $100,000 that's referenced prior to that, deposited into that bank account?
I want to be clear about something. There was $100,000 that was effectively set aside, or delineated, if you will, as it related to Mr. Stoll's claim. That's the $100,000 that is being referenced.
Well, was it set aside? Was it already in the account, or was it deposited into the account?
I don't recall as I sit here today, Mr. Keathley. What I do recall is that we asked Mr. Stoll to tell us what he was due under a quantum merit theory, pursuant to the express terms of the contract, and he refused to tell us. And therefore, we came up with the decision that the maximum amount that Mr. Stoll or his firm could possibly be owed under any scenario would be $100,000.
When you say we came up with the decision, who is the we?
The firm.
Did you discuss this decision with Mr. Parrish and Mr. Fitzgibbons?
I don't recall.
I'm going to show you a document which we'll mark as Exhibit 26, 27.
Are we done with this?
Not yet.
Is there a question?
You've seen this document before?
No.
You'll see in the upper portion of it where it says this statement was May 31st to June 30th, 2011. Do you see that?
I think that's just the dates of the statement and prior statement.
That's correct.
Okay.
I see that.
Okay. And if you go down where it says deposited and credits, you see that?
Yes.
It's on the front page?
Yeah.
Okay. And there's no $100,000 deposits indicated there, is that correct?
I can read what you read. I don't see a $100,000 deposit on this piece of paper.
Okay, and right above that, it says previous balance, $101,000, $18.18, correct?
Yes.
Show you another document which will mark as Exhibit 28. And this is the California Bank and Trust account. It's the same account number, 3260157849. And it's for the statement dates of June 30, 2011 through July 29, 2011. Do you see that?
I see those words on the page, yes.
Okay. And down where it says deposits, there is no $100,000 deposit, is that correct?
There's no $100,000 deposit listed on this page.
Correct. And so the statement that on Exhibit 25, I'm sorry, on Exhibit 26, this amount was deposited into the firm's bank account at California Bank and Trust, account number 3260157849, in approximately May of 2011 is incorrect, isn't it?
I disagree.
And you disagree because of what?
Because my best recollection is that that's when the money was set aside. Now, I may be wrong about that, but that's my best recollection.
And the documents that I just showed you do not refresh your recollection, is that correct?
No.
Take a look at Exhibit 10 in the book in front of you, would please.
You want me to read the entire document?
Yes. I'm going to ask you questions about it.
Okay.
Who drafted this document?
I don't recall, but I believe I did.
Why was this document drafted?
So that me and my firm had adequate authorization to distribute money to Mr. Panish's firm pursuant to Rule 2200 and Chambers v. as well as its progeny.
Do you have conversations with Mr. Parrish and Mr. Fitzgibbons prior to June 6th, 2011 about the contents of this letter?
I believe I did.
And what did you tell them?
As it relates to this letter,
Yes.
I don't recall. I don't recall what we discussed relating to this particular letter, Exhibit 10.
Did you have any conversations with Mr. Parrish and Mr. Fitzgibbons about paying Mr. Panish's firm?
When?
Prior to June 6, 2011.
Yes?
How many conversations did you have with Mr. Parrish and Mr. Fitzgibbons about paying the Panish firm?
I don't remember how many.
More than one?
I think it was more than one. It may have just been one, though. I really don't recall.
And what do you recall about that conversation?
I recall generally we discussed that Brian was entitled to be paid. We discussed the amount that he was to be paid, and we discussed why he was to be paid. And then all of that was encapsulated into this letter, Exhibit number 10.
And did you suggest this amount to be paid to Mr. Panish's firm?
I don't recall if I suggested it or how the exact number was arrived at.
Mr. Panish's firm was entitled to 35% of the total attorney's fees. Is that correct?
I don't recall exactly what his firm was entitled to as far as a percentage basis. What I do recall is ultimately it was agreed that he would receive X dollars, and I think it was $5,250,000.
Take a look at
Well, I know the fee sharing agreement provided for 35%, as I recall, if that's what you're going to ask me about.
I was.
Okay. I mean, I believe that's the number that's in that
You
agreement.
need me to help you look for an exhibit?
No, there we go.
Okay.
And why is it that Mr. Panish's firm was only paid $5,250,000?
Because that's what was agreed upon with the clients and Mr. Panish. And myself. And as I recall, there was some issue relating to a reduction in the attorney's fees or something. I don't recall the details.
What do you mean there was an issue regarding the reduction of the attorney's fees?
There was some issue that the total fee was going to be less than 40%, as I recall. I have a vague recollection of that.
And who brought up this issue?
I don't remember.
Did you have a similar letter of June 6, 2011, Exhibit 10, between your firm and Mr. Parrish and Mr. Fitzgibbons?
Not that I recall,
Why not?
because it wasn't necessary.
And why wasn't it necessary?
Because it wasn't required.
Why was it required with respect to Mr. Panish?
Because, as I recall, either the clients or Mr. Panish wanted to have this piece of documentation relating to the attorney's fee sharing provision or fee share that was to occur. And I likewise believed it was necessary under 2200 in Chambers v. K.
And why did you believe it was necessary under Chambers v. K and versus K and 2200 not to have one between you and Mr. Parrish and Mr. Fitzgibbons?
Because it's not required under the law.
Prior to June 6th of 2011, Had you indicated to Mr. Panish that you were not going to pay him any of the attorney's fees?
No, I don't believe so.
Do you know whether or not Mr. Panish is seeking the additional $250,000?
Well, I don't understand what you mean by the additional $250,000.
Do you understand? Do you have any understanding that Mr. Panish wants the full amount of his 35% of the attorney's fees?
I don't know.
Subsequent to June 6th of 2011.
I don't know what you mean by the full amount of his 35%. This was the agreed upon amount that was agreed Mr. Panish would receive. There was this issue about the reduced attorney's fees. I don't recall the particulars about it, Mr. Keathley, but to the best of my knowledge, Mr. Panish is not claiming any additional monies.
Did you prepare a document in which the original fee sharing agreement was rescinded?
I don't remember.
When was it decided that Mr. Panish was going to be paid $5,250,000?
Around the time of this letter.
Was there an arbitration or a mediation scheduled prior to June 6th of 2011?
I don't remember. There may have been, but there was no dispute with Mr. Panish.
On around June 6th of 2011, did you have any conversations with Mr. Panish about distributing any of the attorney's fees to Mr. Stoll's firm?
I may have.
What do you recall?
As I sit here today, I don't recall what the content of that discussion was.
Did you have any conversations with Mr. Panish prior to June 6th of 2011 regarding your interpretation of the fee sharing agreement, that it did not comply with Rule 2200 or Chambers v. K?
I believe that I did.
And what do you recall about that conversation?
Other than that, not a lot.
And did Mr. Panish share the same view with you?
I don't remember. Are you done with Exhibit 10?
No,
Okay.
I don't think so. In the second paragraph, there are items A through H, which you have indicated were reasons why Mr. Panish should be paid the $2,550,000. Did you discuss these items with Mr. Panish prior to June 6th of 2011?
I'm sure I did.
Recall how much time Mr. Panish or his firm spent assisting with the drafting and filing of the complaint?
I don't. I know it was a lot more time than Mr. Stoll and his firm spent.
How do you know that?
Because I was party to those communications.
Did you see any time records from Mr. Panish's firm regarding any of the work that he did in the floor case?
I didn't need to.
That wasn't my question. My question is, did you?
I didn't need to, so therefore no.
How many motions did Mr. Panish's firm review?
I don't remember exactly, but I remember it was a number of them.
And you indicate that he also reviewed discovery responses?
Yes.
And what did Mr. Panish's firm do with regard to assisting in the drafting of motions and discovery responses?
Just that. They assisted with the drafting of motions and discovery responses.
How much time did they spend doing that?
I don't know, but it was a lot.
Do you have any documentation whatsoever as to the amount of time that Mr. Panish's firm spent drafting motions and discovery requests.
I don't have time records if that's what you're asking me, but I think that the documents that have been produced in the case show the involvement of Mr. Panish and his firm in connection with this matter. Brian and I spoke often about this case, and I sought his counsel and his advice, and he provided input and was very, very helpful in connection with the case. He did more than his fair share.
And how is it that you were brought into this case? You recall?
I'm going to rely on my prior answer that we went over all of this, Mr. Keathley, in the first volume of my deposition at length. I told you about stepping off the plane in Miami and how I either had a message from Mr. Panish or he called me. I told you about the discussion that we had. I told you it was at night on the East Coast. I'm going to stand by my prior answer.
I also asked you a question in your first deposition which you didn't answer, and that is, did Mr. Parrish indicate to you that he was Mr. Stoll's client prior to the signing of the retainer agreement?
No, Mr. Stoll lied to me and told me that repeatedly.
That wasn't my question. My question was, did Mr. Parrish tell you prior to the signing of the retainer agreement that he was Mr. Stoll's client?
Same answer.
What about Mr. Fitzgibbons?
Same answer.
Did Mr. Parrish ever tell you that he was Mr. Stoll's client prior to May 31st, 2011?
Well, clearly after we signed the engagement letter, then he was Mr. Stoll's client. So I don't understand what you're asking me.
Okay. Did Mr. Parrish ever tell you prior to May 31st, 2011 that Mr. Parrish was not Mr. Stoll's client?
He did tell me that at some point in May or June. Both he and Mr. Fitzgibbons told me that.
And what did they say?
They told me that they did not have an attorney-client relationship with Mr. Stoll, as Mr. Stoll had claimed, prior to the execution of the attorney-client agreement. And I told them that Mr. Stoll had represented to me repeatedly that these were, quote, his clients, and that he had an attorney-client relationship with them, and that they had effectively signed up, quote, unquote, with Mr. Stoll. And that representation had a significant amount to do with why I ever agreed to the attorney-client agreement with Mr. Stoll.
Did Mr. Parrish and Fitzgibbons indicate to you that they had any type of relationship with Mr. Stoll prior to signing the retainer agreement?
I don't understand the question.
Okay. Wasn't there a lawsuit that had been filed prior to the signing of the retainer agreement on behalf of Mr. Parrish and Mr. Fitzgibbons?
Yes, we went over that last time.
Okay. And did Mr. Parrish and Mr. Fitzgibbons say that they had any type of relationship with Mr. Stoll prior to the signing of the retainer agreement?
I'm confused. Are you talking about prior to the signing of the agreement, or are you talking about prior to the filing of the complaint? Because as we talked about the last time in Volume 1, there was a number of discussions that occurred. Ultimately, then a complaint was filed as a placeholder. Then a fee agreement was entered into. So I don't quite understand what the timing.
The timing is prior to the filing of the retainer agreement. That's my question.
Prior to signing the
The signing of the retainer agreement.
did they tell you
Can I get a question, please?
Sure. Did Mr. Parrish and Mr. Fitzgibbons indicate to you they had any type of relationship with Mr. Stoll prior to the signing of the retainer agreement?
No.
Do you know how Mr. Parrish and Mr. Fitzgibbons met Mr. Panish?
I believe Mr. Stoll introduced them to Mr. Panish
And how did you come about that information?
because Mr. Parrish and Mr. Fitzgibbons told me that.
And did they tell you why Mr. Stoll introduced them to Mr. Panish?
Well, they told me in May or June of 2011 that Mr. Parrish had met Mr. Stoll at a cocktail party or a holiday party of some sort. Started talking to Mr. Stoll about this case that he had, and that he thought that there was another potential lawsuit that could be brought, and that Mr. Stoll took an interest in this and told them that they should meet Brian Panish. There was a subsequent meeting that was set up at Mr. Panish's office, and Mr. Parrish recounted for me that when he walked into Mr. Panish's office, Mr. Stoll was there. And he was rather surprised that Mr. Stoll was there because as far as he knew, Mr. Stoll wasn't going to have any continued involvement in connection with this matter. That there was a meeting that occurred, then subsequently I got involved, conference calls happened, and ultimately the attorney-client fee agreement was signed after the filing of the initial placeholder complaint.
Did Mr. Parrish or Mr. Fitzgibbons make any comments to you about Mr. Stoll's continued involvement in that case between the signing of the retainer agreement and May 31st, 2011?
I don't understand the question.
Did Mr. Parrish or Mr. Fitzgibbons complain to you as to why Mr. Stoll was still involved in the lawsuit from the signing of the retainer agreement through May 31st, 2011?
Did they complain to me that he was still involved?
Yeah.
No, because at that point he was supposed to be involved. He was supposed to be working on the case and doing his part.
Did they complain to you at any time prior to May 31st of 2011 that Mr. Stoll or his firm were not doing enough work on their case?
Yes, there were repeated occasions where they voiced to me a concern as to, where's Bob? What is he doing? What's going on with Bob? They were especially upset about Mr. Stoll's conduct at the first deposition in the case, or one of the first depositions in the case of Mr. Johnson, where Mr. Stoll showed up with a bunch of personal injury files and sat at the conference room table working on other files as the deposition proceeded. We talked about that the last time.
How do you know they're personal injury files?
Because he told me what they were. And you could tell they were personal injury files because they're not substantial files like this case. And generally that's what Mr. Stoll does, is personal injury work.
Turn to Exhibit 18, if you would, please, which is a letter dated May 30, 2011. Are you familiar with this document?
I've seen the document before.
Did you prepare it?
I don't recall.
Did you have a conversation with your clients prior to them signing this document on May 30th, 2011?
They told me that they were terminating Mr. Stoll, and they were going to be sending a letter. Beyond that, I don't recall.
Did they tell you why they were terminating Mr. Stoll?
Yes.
And what did they say?
Because he had not done what he was supposed to do in connection with the case, that his work was substandard, and that he had counseled them to commit tax fraud, among other things. And they were very upset by his conduct.
Did you suggest to Mr. Parrish and Mr. Fitzgibbons that they terminate Mr. Stoll?
No.
And why, did they tell you why they were waiting until May 30th of 2011 to terminate Mr. Stoll?
No.
Did you indicate to them that by them terminating Mr. Stoll, they could get sued by Mr. Stoll?
I don't recall. Probably not, because the contract specifically stated that each attorney could be terminated at any time. And in my experience, the words "at any time" mean at any time.
Do you have anything in writing in which you discussed with Mr. Parrish and Mr. Fitzgibbons them sending this letter to Stoll, Nussbaum, and Polikoff?
Not that I recall.
Do you know where this letter was sent from to Stoll, Nussbaum, and Polikoff?
I don't remember. I knew at one point. I just don't recall as I sit here today.
Did you indicate to Mr. Parrish, Mr. Fitzgibbons, if SNP sued them, that you would defend them based on this termination letter?
I think I'm going to object just because that calls for attorney-client privilege communications on this matter. I think we have to segregate. While I'm willing to let them testify as to your relationship with them, subject to our stipulation relating to the underlying matter, I'm going to instruct you not to answer any questions about your communications on this matter.
Well, I don't think there was this matter at that time.
If it even considered potential litigation between Mr. Stoll and the clients, I'm going to instruct you not to answer.
Let's go ahead and mark that. Did you tell Mr. Parrish and Mr. Fitzgibbons, as of May 30, 2011, you did not believe that the fee sharing agreement was enforceable?
I don't remember.
Did you tell Mr. Parrish and Mr. Fitzgibbons, as of May 30th, 2011, you did not believe that the strike that. Did you discuss whether or not Mr. Fitzgibbons and Mr. Parrish were going to send such a letter to Mr. Panish?
Generally, but not in those terms.
And what did you discuss?
Well, it was discussed that neither me nor my firm nor Mr. Panish nor his firm were being terminated. That the representation was going to continue in the matter that was the subject of the attorney-client agreement.
Attorney-client what?
Agreement?
Turn to Exhibit 6, if you would, please.
I don't know if we have that here, Jim.
It's, no.
It starts on 8.
Yeah, we have it. and bring it. Did you have any conversations with Mr. Panish regarding the lien provisions in the retainer agreement?
I don't remember. I may have.
Did you have any conversations with Mr. Panish regarding the letter that Mr. Grassini sent to you on June 3rd of 2011?
Yes.
And what did you discuss with Mr. Panish regarding that letter?
I told him it was an absolute joke, among other things.
And what did Mr. Panish say?
As I recall, we laughed about the letter, or at least we had a discussion during which we laughed about the letter.
What were you laughing about?
Well, because it was an absolute joke.
And why do you say it's an absolute joke?
Well, because it's false. The letter is absolutely false, and it was designed to attempt to intimidate me and my firm, and it did not work. And Mr. Stoll should have known better than to have Mr. Grassini send such a letter. It was ridiculous. And it showed a complete misunderstanding of what the issues were, and it showed that Mr. Grassini was just as ill-informed and misinformed as Mr. Stoll. So that's why I thought it was a joke.
Did you discuss with Ms. Pansky Mr. Stoll's lien rights?
I may have, I don't recall.
I'm sorry?
He said he may have, but he doesn't recall.
Just looking at Exhibit 10, in any way refresh your recollection as to how much money your firm was paid for attorney's fees in this matter?
No.
Was the remaining balance that was not paid to Mr. Panish paid to your firm?
I don't recall.
Was any of that money, the remaining balance that was not paid to Mr. Panish, did it go to Mr. Parrish or Fitzgibbons?
I don't recall.
Of the remaining attorney's fees that were not paid to Mr. Panish's firm, did you direct or suggest to your clients how much money your firm should be paid?
I don't recall.
Other than the $100,000 that was contained in the bank account that we discussed, what happened to any of the remaining monies that Mr. Stoll was claiming to be owed?
I don't recall.
you have any conversations with Mr. Panish at the time you signed the fee-sharing agreement that you believed the fee-sharing agreement did not comply with Rule 200 or Chambers v. K?
I don't remember. I don't think so.
Prior to May 31st of 2011, did you have any conversations with Mr. Parrish or Mr. Fitzgibbons about your belief as to the enforceability of the fee-sharing agreement?
I may have. I don't remember one way or the other as I sit here today.
And prior to May 31st of 2011, did you have any conversations with Mr. Panish regarding your legal interpretation of the enforceability of the fee-sharing agreement?
I think you asked me that before. Same answer.
Why did you send, or did you send discovery requests to Mr. Panish's firm for his review?
I'm sorry?
Did you send to Mr. Panish's firm discovery requests for his review?
During the pendency of the case?
Yes.
Yeah, you're not talking about this case, you're talking about the underlying case.
Correct.
As I recall, yes.
And why was that?
Well, I don't know if I did it or someone else in my office did it, but as I recall, yes.
And why did you do that?
Because I wanted to get their input.
After Mr. Johnson's deposition, did you tell the clients that they should terminate Mr. Stoll's firm?
No.
And after Mr. Johnson's firm, why wasn't SNP terminated
After his deposition.
after his deposition?
I don't know. That wasn't my decision.
You didn't suggest it to the clients that they should terminate him?
You just asked me that. No.
After the first mediation that took place, did you suggest to Mr. Parrish and Mr. Fitzgibbons that SNP be terminated?
No.
Did Mr. Parrish or Mr. Fitzgibbons indicated to you that they wanted to terminate SNP after the first mediation?
They indicated to me that they were not happy with Mr. Stoll. I do not recall them discussing termination with me at that time.
Was the only time that they discussed termination of SNP with you was right prior to May 30th of 2011?
I don't remember.
Mr. Panish was not at the first mediation, is that correct?
That's correct. And again, I don't remember if technically it was a mediation or a mandatory settlement conference.
Understand. Did you ask Mr. Panish to attend?
No. As I recall, he was available by phone.
Did you have any conversations with Mr. Panish prior to entering into the retainer agreement about the number of business cases that Mr. Stoll had been involved in?
Not that I recall.
Did you ask Mr. Panish the number of jury trials that Mr. Stoll had done prior to entering into the retainer agreement?
No.
Did you ask Mr. Panish the number of jury trials Mr. Stoll had tried to verdict prior to May 30th of 2011?
No.
After the second mediation, did you have any conversations with Mr. Panish regarding Mr. Stoll's conduct during the second mediation?
Yes.
How many conversations did you have?
At least one, if not a few.
And what was that substance of those conversations?
Generally what I testified to previously on the first day of my deposition, namely that I found Mr. Stoll's conduct to be ridiculous, outrageous, unethical, substandard, etc.
What did Mr. Panish have to say about that?
I don't recall what Mr. Panish said, but he was not complimentary towards Mr. Stoll. I do recall that.
When you say was not complimentary, but you don't recall what he said.
Well, I remember him telling me that he'd had a number of fee disputes with Mr. Stoll, and that he had generally decided he wasn't going to work with Mr. Stoll any longer. He was tired of dealing with him.
Anything else?
I mean, not that I can recall as I sit here today.
Did you take any notes of any of the conversations you had with Mr. Panish?
No.
Then we go off the record for a couple minutes, take a break.
Sure.
This concludes media one. Today's proceedings in the deposition of Michael Avenatti, volume 2. The time is approximately 11:41 a.m.
Yeah.
We're back on the video record. This begins media 2 in the deposition of Michael Avenatti, volume 2. The time is approximately 11:50 a.m.
Mr. Avenatti, did you send any discovery responses to S&P for review prior to the discovery responses being sent out?
I think so.
And were they reviewed?
I don't believe so.
Did you receive any comments back?
I don't believe so, but again, without having the documents, I don't have a firm recollection.
And with respect to any motions, did you send any motions before they were sent to be reviewed by S&P?
Before they were filed?
Filed.
Yes.
And did you get any type of feedback from S&P?
I think on occasion we did.
Okay. What about oppositions to motions? Did you send any oppositions to motions to S&P for review?
Yes.
And did you get any type of response back?
Same answer. We would get responses back which would demonstrate a complete misunderstanding of the case,
And when
generally speaking.
And when you got these responses back that demonstrated a complete lack of understanding, did you contact anybody at S&P about those?
I had discussions with Bob Stoll during which I voiced my displeasure as to some of the things that he was suggesting that we do in connection with motions and otherwise, because it didn't make any sense in light of the claims and defenses in the case.
And what did Mr. Stoll have to say in response to you telling him that you're basically not happy with his input?
Well, he wanted to debate the issue with me. I don't recall the exact circumstances I sit here today, or circumstances, but it became pretty clear that Mr. Stoll was not aware of the facts of the case, the legal theories of the case, and generally was in over his head in connection with this case. And I can remember a specific instance of sitting at a place, I think it's called the Coffee Cat. It's a coffee shop right across the street from the courthouse in Santa Barbara, before a key motion was supposed to be argued. I don't think it was the anti-SLAPP. I think it was a motion for summary judgment or summary adjudication, but I may be wrong about that. And Mr. Stoll started telling me his view of some of the arguments that should be made, and I just found it incredulous because it didn't make any sense. And I thought if those arguments were made, it would surely result in the case being adjudicated in favor of the defendants and not our clients.
Okay. Did you express to Mr. Panish you felt that Mr. Stoll was in over his head?
Yes.
And what did Mr. Panish say?
I don't recall what his exact words were, but I believe he agreed.
Do you know whether or not Mr. Panish and Mr. Stoll have had any other cases together since May of 2011?
I don't know. I don't know what cases were pending between the two of them. I don't know.
Has your firm paid S&P any money in attorney's fees on the floor matter?
I don't believe so.
Have you paid any costs that were incurred by S&P?
I don't believe so.
Has Mr. Parrish directed your firm to pay S&P any money in attorney's fees?
No.
Has Mr. Fitzgibbons?
No.
Whose discretion is it to pay S&P any of the attorney's fees between your firm, Mr. Parrish, and Mr. Fitzgibbons?
Well, I'm going to object. That's clearly privileged information. I may instruct you not to answer.
It also calls for a legal conclusion.
I think that
I can't answer the question. I don't understand the question as phrased.
Has Mr. Parrish told you not to pay S&P any of the attorney's fees?
Yes.
Has Mr. Fitzgibbons told you not to pay S&P for its attorney's fees?
Yes.
Has Mr. Parrish told you not to pay any of the costs that were incurred by S&P?
I don't recall. He may have. I don't recall.
Be the same answer for regarding Mr. Fitzgibbons?
Yes.
You're right there.
Did you receive more than $4.6 million in attorney's fees on the floor case?
I don't recall.
Mr. Parrish and Mr. Fitzgibbons direct you to file the malpractice suit against Mr. Stoll and his firm?
That's in connection with this case.
Right.
And so I'm not going to answer any
I'm
questions.
instructing you on that.
All right.
That's privileged relating to this lawsuit. You cannot answer that.
Are you aware of any emails or letters from your firm to S&P complaining about S&P's representation of Parrish and Fitzgibbons in that matter?
Yes.
How many?
I don't recall how many.
Were they written by you?
I believe so.
Was it an email or a letter?
I don't recall.
Do you know what it said?
Generally, it expressed exactly what you asked me, but beyond that, I don't recall the specifics.
Was there more than one writing to that effect?
There may have been, I don't remember.
Did you ever see any letters from Mr. Fitzgibbons or Mr. Parrish to S&P complaining about S&P's representation?
I don't remember.
Did you ever receive any emails or any other types of writing from S&P in which it refused to do any work that it was required to do in representing Parrish and Fitzgibbons?
I'm going to object to the term required to. If you understand it, you can answer.
As I testified to previously, I know that Mr. Stoll asked us to lie to the clients about why he wasn't participating on the conference calls. And as I recall, that was an email that came in, but I may be wrong about that. So I guess the answer would be yes.
And do you know how many?
I don't recall.
Do you recall if there was any writings from Mr. Fitzgibbons or Mr. Parrish to S&P referencing S&P's failure to do any work?
I don't recall one way or the other.
And if you told me every reason why that Mr. Parrish and Mr. Fitzgibbons did not wish to pay S&P its attorney's fees?
Other than what he's testified at the first session and this session?
Yes.
I don't know. Without having those answers in front of me and going through them, I can't answer that question.
When did you tell S&P, Mr. Stoll, that it would not be paid its attorney's fees pursuant to the fee sharing agreement?
I don't recall.
How did you tell them?
I don't recall.
Was it before or after May 31st of 2011?
I don't remember. There were some documents going back and forth, some correspondence, and I just don't remember the dates.
Are you aware of the existence of any tape recordings of conversations between Mr. Stoll and Mr. Fitzgibbons or Mr. Parrish?
One minute.
Yeah. Your Honor, I'm going to object on work product and privilege. Any conversations relating to this matter, any recordings would be confidential, and I'm going to instruct you not to answer.
Well, if the recording was taken without the consent and permission of my client, it violates, what is that, Penal Code Section 98, I believe.
Well, I'll check on that, but for now, I'm going to instruct you.
Well, Your Honor, I would like an answer if...
Oh, sorry, you've been doing fairly well without me. I think it's compound because it says tape recordings with Stoll and Fitzgibbons and Parrish. So
yeah.
you can break it down.
I will break it down. Are you aware of any tape recordings of any conversations between Mr. Stoll and Mr. Parrish regarding
Go ahead.
the floor matter?
It just calls for yes or no, so it's overruled, doesn't say about the content.
No.
Are you aware of any...
Hold on. I want to make sure. Mr. Stoll and Mr. Parrish?
Yes.
No.
Are you aware of any tape recording of conversations between Mr. Stoll and Mr. Fitzgibbons regarding the floor matter?
No.
Are you aware of any type of voice recordings between Mr. Stoll and Mr. Parrish? I'm sorry, yeah, Mr. Stoll and Mr. Parrish.
I don't understand what you mean voice recording.
Voice
Didn't you
recordings
just ask
on-
me that?
No, it's a tape recordings. Voice recordings can be interpreted to be on a phone, an iPad, any other type of recording device.
Between who?
Mr. Parrish and Mr. Stoll.
No.
And the same question with respect to Mr. Stoll and Mr. Fitzgibbons.
No.
Can we take a break?
Sure. Move off the record for a second.
We're going off the video record. Time is approximately 12:05 p.m. We're back on the video record. Time is approximately 12:09 p.m.
Are you aware of any recordings of Mr. Stoll's voice that occurred at any time during the floor matter?
I don't recall.
Do you recall whether or not you were listening in to any conversations between Mr. Parrish and Mr. Stoll without Mr. Stoll's knowledge?
No.
Same thing for Mr. Fitzgibbons?
No.
Okay. Tell me where the $5.46 million that's at issue in this case is.
I've answered that question. I'm going to rely on my prior answer, and I also believe you have an interrogatory response to that effect.
You don't know where it's at.
Nope, that's not what I said.
Mr. Parrish ever tell you that he was dissatisfied with Mr. Panish's representation of him?
Not that I recall.
What about Mr. Fitzgibbons?
Not that I recall.
Did Mr. Parrish tell you that he was having difficulty in getting a hold of Mr. Panish?
He may have, but I don't remember that as I sit here right now.
Did Mr. Parrish indicate to you that he wanted you to tell SNP, Mr. Stoll, to take a reduction of attorney's fees in the sum of $750,000?
He may have, but I don't remember.
Mr. Parrish tell you that he wanted Mr. Panish's firm to take a $500,000 reduction in attorney's fees.
Same answer.
Who is it that decided on the $5,250,000 that was to be paid to Mr. Panish's firm?
Asked and answered.
I'm going to stand on my prior answer in response to that question. It was a collective decision.
Well, at this point, I am not going to conclude the deposition because I still don't have the documents relating to the attorney-client privilege documents that were supposed to be produced. So,
Okay, well, I know, you know our position on this.
Of course.
2025-290 also calls for 7 hours of deposition testimony. We went approximately 5 hours and 18 minutes on the first session, and now we're a little bit north of an hour and 50 minutes, so we've exceeded that amount. And should we use the same stipulation?
we don't have a stipulation.
We've never done a stipulation for the transcript? All right.
Your Honor, one moment, please.
Certainly, take your time.
So I made my 2025-290 position. He's here to answer any questions regarding documents that have been produced, any question regarding ROGs and responses that have been produced. It's your choice to conclude it, and I'd further reserve or take the position, which I don't think is controversial, that this is a confidential deposition covered by the same sealing as the previous session.
My position is that there was a request for production of documents. Those documents were intentionally withheld in violation of a court's order. Your writ was denied. You have filed a petition with the Supreme Court. My guess is you probably won't. And in the meantime, you're not producing documents that you were ordered to. I'm not going to be hamstrung by your failure to produce those documents. And I believe the code also provides upon reasonable request, the deposition time can be extended, and we'll be making that request.
Okay, why don't we have the deposition sent to my attention? He can sign it at your office under penalty of perjury. If the original is lost, a certified copy can be used in its stead, and I'd like 2 weeks after receipt to comment if there are any changes, if that's cool.
That's fine.
Thank you.
But this deposition is not ended.
Well,
We have our
okay.
different
That's-
positions
I
on that.
understand it.
Yeah.
I am not terminating the deposition.
Your position's very clear, Mr. Keathley.
Yeah, you're both quite clear.
Yeah.
I don't think we need a heck of a lot of
All right.
paperwork.
I understand. Why don't we give us 10 minutes and we'll sit up and argue this bad boy?
Sure.
Then we'll see you.
Thank you.
This concludes Media 2 in today's proceedings in the deposition of Michael Avenatti, Volume 2. The time is approximately 12:16 p.m. We're going off the video record.